This video will address the ways that having a criminal record might affect your ability to find housing. As with all of our videos, this video is meant to provide general information and is not legal advice. We'll be going over some general information as well as a few details. Keep in mind that the law changes frequently and that this video is primarily geared toward folks in California. If you have concerns about potential housing discrimination, you'll want to speak to an attorney regarding your specific situation. First, let's talk about private housing. Unfortunately, the law doesn't protect you from housing discrimination based on your criminal record alone. Although California laws make it illegal for private landlords who don't reside in the unit to discriminate against you because of your race, color, national origin, ancestry, sex, gender identity, gender expression, sexual orientation, religion, disability, marital status, family status, genetic information, and source of income, they don't provide any specific or direct protection based on having a criminal record. Landlords have the power to choose their tenants, and judges often side with landlords who claim that banning people with criminal records is necessary to protect other residents or their property. You are, however, protected by state and federal law that limits what a private landlord can learn about you from a background check. A landlord has to tell you about the background check, give you a chance to fix any mistakes that appear on the report, and there's certain information that shouldn't legally appear on a background check. Even though a private landlord is legally allowed to consider your criminal record, the landlord has to apply the same standards to every single applicant. For example, a landlord can't reject a male applicant based on his criminal record and then turn around and accept a female applicant with a similar criminal record. Another example is that if a private landlord conducts a background check on you, they have to conduct the same background check on all the other applicants. It is illegal for a landlord to deny you housing based on past drug or alcohol addiction, as this is a protected disability status. Past addiction as well as current alcoholism are considered disabilities under both state and federal law, so landlords can't deny you housing for this reason or even ask you about past drug or alcohol use. Landlords must also provide you with reasonable accommodations if necessary. However, a landlord may deny you housing if you're currently using or selling illegal drugs. This is the same rule that applies to current drug use in government-assisted housing programs. A private landlord can ask you, either on the application or directly in conversation, about past criminal convictions, arrests, and other criminal activity, and you should answer honestly. But if the landlord's asking you about your past convictions, criminal activity, or conduct, they have to be asking everyone equally. Under state and federal law, you have the right to the following protections if a private landlord runs a background check on you. First, the landlord must give you notice and get written permission to conduct the background check. That means that you have to get a written document from the landlord saying they want to conduct the background check, and they have to get your written permission before conducting that background check. Second, the landlord has to give you a copy of the background check within 3 days of receiving it. In California, you also have the right to request a copy of your report for at least 2 years after the background check company provides your report to the landlord. Finally, the landlord has to tell you if your criminal history is the reason you're not getting the apartment. Now, let's look at how a criminal record can affect public housing. The rules for criminal records are different for every government-assisted housing program and are determined locally. Even an owner of government-assisted housing can have different rules than the public housing authority that oversees the government-assisted housing programs. You'll have to find the specific rules for your program. There are 6 conditions for which an applicant may be banned from government-assisted housing programs: methamphetamine production on federal government-assisted property, sex offense convictions requiring lifetime registry, past eviction for drug-related activity on federal government-assisted property, current illegal drug use, posing a threat to the health, safety, or peace of other residents or staff, or recent violent or drug-related criminal activity. You can increase your chances of admission to government-assisted housing programs by providing evidence like your crime not being recent, your conviction being when you were young, showing you weren't as involved in the offense or conduct as one might think from the conviction alone, physical or emotional abuse, coercion, or untreated abuse or mental illness that led to the conviction. disabilities that you or a family member has that might have led to the conviction, certificates or letters from supervising officers or court documents showing completion of parole, probation, or other supervision, letters of support or recommendations from employers or others, certificates or diplomas for education or training you've received, letters or certificates for completing alcohol or drug treatment programs, and letters or certificates for completion of rehabilitation programs. Now, let's talk about some of the basic rights and practices that apply to everyone in California when it comes to housing. First, tenant rights. Your basic rights as a tenant in California include limits on the amount of the security deposit that the landlord can require you to pay, limits on the landlord's right to enter the rental unit, the right to a refund of the security deposit or a written accounting of how it was used after you move, the right to sue the landlord for violations of the law or your rental agreement or lease, the right to repair serious defects in the rental unit and to deduct certain repair costs from the rent under appropriate circumstances, the right to withhold rent under appropriate circumstances, and rights under the warranty of habitability, and finally, protection against retaliatory eviction. If you suspect that any of your rights have been violated in any way that's detrimental to you, you should try to look into it further and maybe even consult a lawyer. Next, evictions and notices. There are different kinds of 3-day notices. All of these notices have to be in writing. After the 3 days are over, the landlord can't simply put you out on the street, change your locks, or have the police or sheriff evict you without going to court first. The 3-day notice is only the first step in the eviction process, and the landlord has to go to court to get a judge's order in order to either get the rent or get the house or apartment back from you. Most 3-day notices can be corrected without having to actually move out of your apartment or home. The most common is the 3-day notice to pay rent or quit, though a landlord can give other kinds of 3-day notices as well. Another common one is the notice that says that the tenant or a person living in the apartment who's on the lease has created a nuisance or has done something that's not allowed under the rules of the lease agreement. Remember, because it's often time-consuming and costly for a landlord to go through the process of eviction, they may be willing to come to some other arrangements with you if you talk to them about the situation that's affecting your ability to pay rent. Finally, let's address some best practices when it comes to renting. First, you should keep a file with your signed lease and lease agreement and any other important documents. Under California law, a tenant can ask their landlord for a copy of their lease once per year. The landlord must then provide it within 15 days. The file should also include notes of any conversations you've had with your landlord or the apartment manager regarding repairs, disturbances, disputes, or any other event or incident that may affect your rights as a tenant. It should also include any mail, emails, repair orders, or even notes left on your door. Keep and maintain a separate file for each rental unit you live in. Make sure you keep careful records of the rents that you've paid. When you move into a new unit, it can be a good idea to take a lot of pictures of the condition that the unit's in so that you can prove any damage that was there when you moved in and you don't have to pay for it when you move out. Rental insurance can protect your belongings, and it may be a good idea for some people. I hope this video has helped you to become a more informed renter or resident of public housing. It's important to know your rights and responsibilities, as this can save you from losing the housing that you've worked so hard to gain. If you ever run into housing problems that seem suspicious or difficult to understand, make sure to discuss the problem with your coach at the center or with a trusted peer or even an attorney. Thanks so much.